Hello landlords, it's Ernie Garcia, landlord attorney, and today we're talking all about notices. What kind of notices are out there? What should you be sending? And why do you keep getting notices wrong? Let's get started. Now, notices are a huge part of the landlording game, and I know that you guys are interested in getting your cases right, making sure that you're sending proper notice so that the things you want to ask, for example, in a trial, you actually get because you followed the rules, you've got a case, solid facts that you want to present to a court, and you want to get that judgment in order to set things right between you and your tenant. Unfortunately, something as simple as a notice can derail an entire court case. So I want to talk to you about the different kinds of notices you should be sending on a regular basis, how to send them, and when. Now, before we get too far into the kinds of notices that you should be sending, it's important that you understand what your lease already says about where to send notice. Yes, I do know that different states have different rules with regard to how and in what method you use to deliver a notice. But if your lease does not already mention at least a couple of things about notice, you're really probably missing out on some really easy advantages. For example, your notice provision in your lease should properly identify more than one method for you to deliver a notice. Again, your state law may require a very specific method, but if it doesn't, then why not include in the notice provision an email, possibly a backup email, maybe a personal email and a work email. Some people like to communicate via text. If you mention in your notice provision that text is an acceptable method of communication for purposes of notice, that's also helpful. You might have an app that you use regularly to communicate with your tenants, and it's always great to mention that in the notice provision. So whether you're also utilizing fax or some tenant portal or some other method of communication that you can easily print in your lease, I strongly encourage you to add those methods so that when it comes time to give in a good notice, you're able to send that notice in multiple ways just to ensure that your tenant is notified. So I know that different states are going to have different requirements for how a notice is delivered and the kind of notice that you should be delivering. And I'm not going to get too deep into each of the different kinds of notices and the methods of delivery. I am going to talk about notices in a general sense. So yes, you can jump on and chime and say, well, what about this very state-specific kind of notice? Yes, I'm super aware that that's out there. But today I want to talk about notices in general. The first one I want to talk about is a notice of default. Now, your notice of default should clearly identify what provision in your lease your tenant has violated. Don't get general. If you've got a specific provision in your lease and you can point to it and say, this is the thing you were supposed to do that you didn't do, cite that provision. Don't presuppose that stuff's in the lease if you can't actually point to it. It's only a violation if both of you agreed that something would happen and that the tenant had the responsibility to get that done. Don't just presuppose that because it's common sense they violated the lease when they didn't do that thing that you wished they had done. Additionally, the fact that you talked about it is not a provision in the lease unless it's there in black and white. If you've got a written lease, and you can really only enforce the requirements that are stipulated in that lease. Now, generally speaking, when you send a notice of default, you're going to offer an opportunity for your tenant to cure whatever it is they got wrong. If their default is they broke a window, then part of that notice might include the payment of the fees that you're charging them for that repair. Whether you did it yourself or you hired somebody else to do it, that notice should indicate what part of the lease they got wrong and what it is they can do to make it right, i.e. paying that bill. You always want to give a reasonable amount of time for them to get this done and make sure that your notice is clear. What was the violation? How can they cure that violation? And how long do they have to get that done? Remember to be reasonable. Don't, make anything. You got 15 minutes to get this done or else. If it doesn't pass a reasonable standard, don't do it. Generally speaking, a few days, maybe a week, sometimes multiple weeks to get certain tasks completed is reasonable. You're going to make that call based on what it is that you're asking your tenant to get done. One thing I'm asking you to get done, if you can, is give us a like. We always appreciate that. Any questions or comments, leave those below. I will answer those myself. Now, you may live in a state that doesn't allow a landlord to terminate a lease with without cause. So you may be citing cause in your notice of termination as to why your lease is coming to an end. If you live in that kind of state, make sure that your notice explicitly states the cause for your termination. In Texas, where I practice, there is no such rule. And so as long as you sent a timely notice, you can terminate a lease that is either coming to an end or that has turned into a month-to-month lease that you now want to come to an end. The dates are important. If you're timing something out and you have to give at least 30 or 45 or 60 days notice, make sure that you're doing that, and make sure you understand the principle that the number of days that you're asking for a termination don't just mean an arbitrary set of dates. So if, for example, your lease starts in the month of January and ends the end of the month of December, but you need to give a 45-day notice of termination, or else the lease will just lapse into a month-to-month and continue, potentially forever. It doesn't mean that any 45 days within that year are acceptable for the purposes of this notice. Instead, whatever the lease says is the end date before the lease lapses into this month-to-month tenancy, whatever the lease says is that end date is the date from which you back up 45 at least. You could do 46 or 47 or whatever, but you got to give at least 45 days from that end date to your tenant, notifying them that you do not intend for the lease to lapse into that month-to-month status, and you do not intend to continue with that lease. Hence, the termination. And so make sure that you're conscious of the number of days required and make sure you've given at least that much time of notice to your tenant that you mean to terminate a lease. The same is true for a notice of non-renewal. You may have to inform your tenant that you're simply not interested in renewing a lease that is coming to a natural end. It's helpful to be crystal clear on this fact so that if they do happen to stay beyond a date of termination, whether your lease has a hard end date or not, you want to be able to demonstrate to a court, should it get there, that you gave proper notice in a timely manner to your tenant, letting them know that you had no intention of renewing that lease. And if in your state you have no obligation to do that, then sending that notice could be a helpful tool that you could use at a later date to prove what we refer to as holdover. And holdover occurs when a lease either has a natural ending that is violated by the tenant, or when you've given proper notice of termination or non-renewal to a tenant and they simply ignored it. Understand that just because a lease is terminated and a tenant has overstayed, the requirement to pay rent has not expired. However, if you willingly accept rent, you might in effect waive your right to end that lease. So be conscious of what's going on between you and your tenant. You don't want to send a mixed message. You could, for example, send that notice of termination or notice of non-renewal, and then your tenant sends you 1 month of rent beyond that date. By taking it and depositing it, you essentially have extended that lease for another month. And if you send this conflicting message to your tenant and then attempt to evict them, a court might state that you have invalidated your notice by your action. However, if someone stays and you clearly let them know, look, I am not interested in you holding over beyond this point. I am now issuing a further notice. The last notice on our list, the notice to vacate. Now, this should be an unequivocal demand for possession. And by unequivocal, you are stating, that's it. We're at the end of the line, so that your tenant clearly understands. It's not an if, then this. It's a you gotta go. That clear message should make it very evident to your tenant that you have no intention of letting them stay. You are demanding that they leave. Different states are going to require different number of days for a notice to vacate, but whatever the requirements are for you, make sure you understand those requirements based on the state where you're living and based on the terms of your own contract, because your contract might grant additional days over and above what your state says is the minimum number. And if your contract has done that for whatever reason, you must honor it. Otherwise, they can present that term to the court, and now you've got an invalid notice to vacate and probably a losing eviction matter. And now you got to start the whole process over. I know that sometimes people like to send their notice to pay or quit, which is a notice to vacate, but it gives an option for the tenant to submit payment. And generally speaking, there's nothing wrong with that unless in your mind you are certain you do not want this tenant to stay. So even if they offered you the rent, you wouldn't take it. Some states don't allow you to do that. Some states require you to accept rent, even if it's late, from your tenant in order to avoid an eviction. That's not the case in the state of Texas. So if what you mean is you gotta go, make sure your notice is unequivocal in your demand for that tenant to leave. Essentially, every one of your notices, whether it's a notice of default, a notice of termination, a notice of non-renewal, or a notice to vacate, should be crystal clear to your tenant. There should not be ambiguity, whether it's in what you're asking for or how, if at all, your tenant can fix that thing, or if there's some kind of time limit on that notice, what precisely that limit is. Any ambiguity in any of your notices can be used against you. Typically, a court is going to resolve a reasonable ambiguity, some reasonable inference that you could go this way when you meant for it to go this way. If your statement in your notice is ambiguous and can be taken this way or that, the court is likely going to find in favor that is the most convenient for your tenant. You can't be sending ambiguous notice and expect the court to always see it your way. And so the best solution for this is not to send an ambiguous notice. Make sure it is crystal clear that a third grader could understand precisely what it is you're asking, and you're always going to get a better result. For better results out of your landlording, make sure you're watching all of the content on this channel. YouTube seems to think this video is the next best thing that you should watch. I welcome you to watch it, and until next time, happy leasing.